Testing, testing.
Hey, welcome to the Public Service Commission's administrative meeting for October 1st, 2025. Before we get to the official business, I usually use this time to announce new employees of the commission, but today we're not announcing a new employee, but a promotion of a current employee. DeAndre Wilson has been appointed as Assistant Chief Engineer for Distribution for the Public Service Commission. DeAndre is a frequent flyer at these meetings and has been at the commission since 2012 as a engineer in our engineering division, and he has a degree in electrical engineering from Morgan State University, and we welcome on DeAndre's new responsibilities and look forward to his participation in further proceedings. And with that, we will adopt the minutes from our last administrative meeting of September 24th. Commissioner McLean?
Aye.
Commissioner Linton?
Aye.
Commissioner Suchman?
Aye.
I vote aye.
Good morning, Mr. Chair. There are 14 items on today's agenda, but we will actually be deferring 4 items today. Items number 9, 10, 11, and 13 to future meetings. With that, we will start with the consent agenda. And item number 1 is for Southern Maryland Electric Cooperative, Inc., filed its revised tariff pages with updates to its residential electric vehicle time of use adjustments to its retail electric service tariff. Item 2 is from Cablevision Lightpath LLC and United Federal Data of Maryland LLC, its joint application for approval of an internal reorganization and participation in certain financing arrangements. Item 3 is from Hanover Insurance Company, its bond cancellation for NLX North America, Inc. And number 4 is from Resource Energy Systems LLC, its notice and request for approval of equity transaction and licensing change in control.
Okay, regarding item 1, I move we accept the tariff provisions for filing with an effective date of October 3rd, 2025. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye. Item 2, I move that we note the pro forma reorganization application and approve the financing transition as proposed by Cablevision Lightpath LLC and United Federal Data of Maryland LLC. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye. Regarding item 3, I move that we cancel the company's natural gas supplier license. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye. And regarding item 4, I move that we note the filing. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye.
Okay.
The next item is number 5 on the administrative agenda from TransSource Maryland LLC, Baltimore Gas and Electric Company, and the Potomac Edison Company. It's update of joint request for extension of deadlines and joint request for additional commencement extension.
Good morning, Chair Hoover and Commissioners. Roger Austin presenting on behalf of staff. This item is a continuation of a matter that was considered at the January 29th, 2025 administrative meeting. On November 13th, 2024, TransSource Maryland LLC, TransSource Maryland, Baltimore Gas and Electric Company, BGE, and the Potomac Edison Company, PE, filed a joint request for additional extensions of previously extended construction commencement deadlines for CPCNs and CPCN waivers that were granted to each company in case numbers 9470 and 9471. At the time of filing, the companies were still awaiting the resolution of pending federal court litigation challenging the Pennsylvania Public Utility Commission's order denying TransSource Pennsylvania LLC's application for a CPCN to construct the portions of the IEC project located in Pennsylvania. The various portions of the IEC project and the PE rebuild project are part of the larger Project 9A. No part of Project 9A can proceed if any other part has not received the necessary regulatory approvals. The companies requested additional extensions until December 31st, 2025 for each construction commencement deadline of the CPCNs and CPCN waivers that were granted to the companies. On December 11th, 2024, staff requested additional time before the expiration of the company's construction commencement deadlines of December 31st, 2024 to complete its due diligence. On December 19th, 2024, the Commission granted a temporary extension to January 31st, 2025 of the company's construction commencement deadlines. At the January 29th, 2025 administrative meeting, staff expressed concerns that PJM's 2024 re-evaluation of Project 9A showed that the project created uncontrolled congestion and potential reliability violations, and the benefit-cost ratio was now 0.81. Nevertheless, staff acknowledged that PJM still supported the project and wanted to perform a new re-evaluation with updated system data. Staff recommended that the Commission grant the companies the construction commencement deadlines that they sought. After considering the matter, the Commission temporarily extended all deadlines for an additional 60 days to April 2nd, 2025. On March 18th, 2025, TransSource Maryland filed a request with the Commission seeking an additional temporary extension of the construction commencement deadlines until after PJM's May 2025 Transmission Expansion Advisory Committee TIAC meeting. On March 19th, 2025, the Commission granted a temporary extension until May 31st, 2025. On May 8th, 2025, TransSource Maryland filed an update in which it revealed that PJM's 2025 reevaluation of Project 9A had a benefit cost ratio of 3.42. On May 20th, 2025, the parties filed a written request to the Commission to grant an additional extension of relevant CPCN and CPCN waiver construction commencement deadlines for the IEC project to May 31st, 2026, or in the alternative, grant the parties currently pending joint request for extension of relevant deadlines to December 31st, 2025. No, 2025. On June 2nd, 2025, the Commission gave notice that it further extended TransSource Maryland's request for a temporary extension until which time the Commission can schedule the matter at an administrative meeting and render its decision. At PJM's June 4th, 2025 TIAC meeting, PJM acknowledged that there are challenges building the eastern portion of Project 9A. Multiple projects were approved after Project 9A was suspended in 2021, and some occupy the same physical location or transmission line rights of way that the eastern portion of Project 9A had intended to occupy. The western portion of Project 9A shows a benefit cost ratio of 3.85 and continues to address market efficiency planning needs on the AP South reactive interface and related facilities. The PJM Board of Managers therefore voted on July 30th, 2025 to approve only the western portion of Project 9A. PJM's vote therefore means that the eastern portion of Project 9A, which was supposed to be built by BGE, is no longer needed. To date, BGE has expended approximately $8.6 million in preparation to construct its portion of Project 9A. BGE stated that approximately $1.9 million of that $8.6 million could be transferable to another project. BGE has not indicated whether or how much of the remainder of what it has spent on the project will be requested in abandonment cost. Staff recommends that the Commission grant an additional extension of the CPCN that was issued to TransSource Maryland LLC to build a new 230 kV transmission line in Washington County and extend the construction commencement deadline specified in case number 9471 to May 31st, 2026. Grant an additional extension of the construction commencement deadline of the CPCN that was issued to the Potomac Edison Company to upgrade and rebuild an existing 138 kV line in Frederick and Washington counties, as specified in case number 9470 to May 31st, 2026, and allow the two CPCN waivers that were issued to Baltimore Gas and Electric Company in case number 9471 to add two new 230 kV transmission lines in two of its existing rights of way in Baltimore and Harford counties to expire. And as a final note, counsel for BGE contacted staff counsel by email to let us know that BGE received official notification from PJM that PJM no longer needs the eastern portion of the IEC project built, and therefore BGE does not object to our recommendation to allow their 2 CPCN waivers to expire.
Okay, any questions for staff? Commissioner Schlesman.
Morning, Mr. Austin.
Morning, Commissioner.
Has BGE shared with you what that 8.6 million that has been expended was expended on? And when the spend occurred?
No, we do not know exactly what they spent that on. We can only surmise there was engineering design. They might have also acquired some hardware, some equipment, but we don't know exactly what they expended that 8.6 million on.
Okay. And then just to be clear, because these CPCNs are expiring, these projects are done. We're not expecting any new requests. You're not expecting any new requests. These projects are not being the projects are not being built.
The when you say
On the eastern portion is
right.
not being built
they're done, yeah,
and will not be built.
and will not be built except BGE, if you recall, back in February, BGE applied for a CPCN waiver for 2 transmission line rebuilds. One of those rebuilds was what they were going to have to do for this eastern portion of the IEC project. The BGE, is it? Grayston to Manor line, Grayston to Manor 230 kV line. They were going to have to tear down 8 transmission towers and add a second 230 kV line to what is now a single circuit line. And that CPCN waiver they came in for and were granted back in February was to do that exact same project, except they're only they're tearing down the towers, adding 1 transmission line, 1 circuit, but the other side is going to remain vacant for the time being.
Okay, they do have a CPCN for that second,
right?
But they're not going to go forward with that. They're only going forward with the 1 line.
Right. The CPCN waiver that was granted in February was only to do the 1 line.
Okay. All right. Thank you.
Anybody else? Okay.
Thank you, Chair Hoover. Good morning, Commissioners. Michael Sammartino for the Office of People's Counsel. We appreciate staff's analysis and agree with staff's recommendation to extend the commencement of construction deadline for the western portion of the project and allow the waivers for the eastern portion of the project to expire. As our comments note, the Third Circuit ruling does not yet result in a CPCN being issued for the project in Pennsylvania, and so further proceedings in Pennsylvania are likely required before construction can commence on the entire project. So we recommended that the Commission have TransSource submit periodic updates on the status of the project in Pennsylvania, just to keep everyone appraised as to what's going on and the potential time frame in which construction can commence. And we understand that TransSource submitted a filing yesterday that does not oppose our recommendation. With that, I'm available for any questions you may have. Thank you.
Any questions for OPC? So on the your request for periodic updates, are you looking annually, semi-annually, quarterly?
We were thinking approximately every 3 months, just because it seems like it's a very fluid situation, and there could be full-on evidentiary proceedings. There could be a decision based on the record as it already stands. And every 3 months, I think, would be a sufficient time frame. But that's what we would suggest.
Okay. All right. Seeing no other questions, let me turn to Power Plant Research Program.
Good morning, Commissioners. Sandra McLemore on behalf of the Power Plant Research Program. We filed Monday comments indicating that we also agreed with the recommendation by the staff's technical staff. And also, I would like to indicate also that there may not be sufficient time with this extension to allow some of the companies to be able to comply with some of the conditions that require them to update surveys. I will let Potomac Edison discuss this a longer, but we would not object to additional time, an additional extension for them to be able to comply with those as well.
Okay. Any questions for Power Plant? All righty. Okay, so let me, anyone here from Potomac Edison on this?
Good morning, Mr. Chairman, Commissioners. Robin Leone on behalf of the Potomac Edison Company. As Ms. McLemore just explained, we understand that this May 2026 deadline is a further check-in point. It does not seem as though it is the date by which we will need to start construction on the transmission line piece of this. But we do want to clarify that there are some ramp-up activities that would be required once we do have approval, both in terms of what this commission decides and what may be going on in Pennsylvania. And I'm available for further questions if you have any.
Any questions for PE? All right, seeing none. What about Baltimore Gas and Electric? Do they have anything they want to offer on this? Or?
Good morning, Commissioners. Joel Michelle on behalf of BGE. We have no additional comments.
Any questions for them? All righty. And finally, TransSource.
Good morning, Your Honor and Commissioners. J. Joseph Curran III on behalf of TransSource. Again, thank you for entertaining our request today. I would like to make a few introductions. I do have with me in from Columbus Ms. Stacy Berber, who's the Senior Vice President of Transmission Business Development for AEP, along with Evan Dean, who's also joined us from Columbus as well. Mr. Dean is the Managing Director of Transmission Joint Ventures at AEP. For Commissioner Linton may remember during our TransSource proceedings, Mr. Hector Garcia is also here. He's senior counsel at AEP who helped Mr. Gunderson, myself, and Ms. Shipper try this case back in 2020. And also here today is Mr. Mark Standage from PJM. Mr. Standage is the Associate General Counsel and Corporate Compliance Counsel at PJM, should you have questions for them. First, I want to thank Mr. Austin, Mr. Dean for their work over the last several months with us to keep the Commission updated on the activity at PJM. As we mentioned to you back in January, there was going to be a reevaluation. PJM conducted that and was able to update their model, as we indicated, in order to get the most current topology and load forecast. And when they did that, we're happy to say that the IEC West continues to be very beneficial for the state of Maryland and helping this commission and the residents of the state of Maryland with what we know to be a very serious economic congestion issue. So again, we appreciate staff's analysis that we were able to resolve the concerns that were expressed back in January and are available for questions.
Okay, let me start with one process question. I saw your letter yesterday where you agreed with the idea of having TransSource provide periodic reports, and you heard the comment from OPC that they think quarterly would be the right time frame. Are you have any concerns with that, or?
Not really. We think just based on how this case has evolved over the last several years, we sort of had ad hoc updates, we've had periodic updates, and we think now that we see the light at the end of the tunnel, and as we're moving forward in Pennsylvania, that would be appropriate. It's really, quite frankly, up to the five of you.
Sure.
If you want them to be every 3 months, that is fine with us, and I think that would be agreeable to the
Okay.
company as well.
All right, thanks. So, questions for Transsource? Commissioner Litton.
Thank you, Mr. Chairman. Good morning. Just to follow up with the chairman's question about the updates that you would file, in the event that there are any milestone-related developments, a decision from the courts, something of that sort, it'd be useful to have those updates as quickly as possible, regardless of when it falls in the timeline of the scheduled updates.
We agree with that, Commissioner. The way we've been proceeding now is under the Commission's current orders, if there's a material impact to the project, that's when we advise you. So if you want periodic updates, this on a scheduled basis, that makes sense to us. And of course, if there's a material event, whether it's a court action or a regulatory action, or as Ms. Macklemore indicated, if there's any other developments with the recommended licensing conditions, we'll keep you up to date on that.
Okay, and I guess along those lines, if you had any response to Ms. Macklemore's comment regarding the current timeline as proposed for extension and your ability to meet the conditions that the surveys, et cetera, under that timeline.
Yeah, of course, we have adhered to the Commission's direction, which is to control costs until there's a decision out of Pennsylvania, and we continue to do that. So we'll be monitoring, obviously, our obligations under this Commission's order, and don't feel like there's any impediment right now. And of course, we have very good lines of communication with PPRP, so to the extent that there's a question about any of those license conditions, we'll work with them and keep you all apprised, obviously, as the project develops.
Okay. All right, great. Thank you.
Thank you.
Thank you, Mr. Chairman.
Commissioner Sussman.
Morning, Mr. Curran.
Good morning.
In terms of the west portion of the project, assuming we grant the CPC an extension, are you then just sitting tight and waiting for the Pennsylvania piece to be resolved, or are you ready to move forward on some aspect of the project?
Well, we continue to make sure that we stay in a ready state, Commissioner, and that requires us to maintain our land rights and our easement rights that we've acquired. And I'm happy to say, in that instance, we're close to 80% of those options. So we continue to maintain those, continue to maintain the required equipment that would be necessary should we be given direction from our regulatory friends in Pennsylvania that we can move forward.
Okay. In terms of the equipment, what are we talking about?
Well, I know there's laydown steel, there's the option agreements, and there's a third category in which we provided you in our bench data request. I don't know if there's any additional items that are necessary, but it's really maintaining those contracts in place and make sure we have our land options. I think most of our continuing costs are around maintaining land options.
Right. I think you understand my concern. My concern is, I'm looking at the $8.6 million that was expended for the East project. Some piece of it could be used for other projects, but you have, let's say, $6 million that you may be seeking abandonment costs for. So I want to avoid a situation on the western side where you're expending monies now, not knowing if the project will, sort of better indications that the project's going to go forward, but things can happen. And I just want to make sure that you are not expending monies that will then come back to us in terms of abandonment cost request.
Understand your concern, Your Honor. We're under a direction both from this commission in its 2020 order to manage those costs and minimize those costs, as well as from PJM. So until there is, I am happy to say we've been taken out of suspension and put back into the RTEP. But at this point, we continue to manage those costs very prudently. And I would suggest that we continue to do what we've done every year, which is to provide you all with our annual updated expenditures.
Okay, can you include that in your quarterly report? Is whatever you're expending so that OPC is aware and others are aware, we're aware, staff is aware of what monies are being expended?
Absolutely.
Okay, thank you. That's all I have.
Thank you.
Any other questions for Teresa? So, any questions for PJM? All right. Seeing none. All right. With that, I move we grant an additional extension of the CPCN that was issued to TransSource Maryland LLC to build a new 230 kV transmission line in Washington County and extend the construction commencement deadline specified in case number 9471 to May 31, 2026. Additionally, grant an additional extension of the construction commencement deadline of the CPCN that was issued to Potomac Edison to upgrade, rebuild an existing 138 kV line in Frederick and Washington counties as specified in case number 9470 to May 31st, 2026, and allow the two CPCN waivers that were issued to Baltimore Gas and Electric Company in case number 9471 to add two new 230 kV transmission lines in two of its existing rights-of-way in Baltimore and Harford counties to expire, and direct TransSource to file quarterly reports on progress and significant expenses related to the project, and continue to keep the parties apprised of significant events in the approval process. Commissioner McLean.
Abstain.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
I vote aye.
Thank you.
Item number 6 on today's agenda is from Emmitsburg Kiln Solar LLC. Its request for temporary extension and request for extension of Community Solar Pilot Program operational deadline for the Emmitsburg Kiln Solar Project in Frederick County, Maryland.
Good morning, Commissioners. Harrison Scher on behalf of staff. On August 28, 2025, Emmitsburg Kiln Solar filed a request to extend the operational deadline of its 2-megawatt community solar project in Frederick County by 18 months until February 28, 2027. This is the project's first request for an extension before the Commission. The company requested that the Commission grant a waiver of COMAR 2062-0304C pursuant to COMAR 2062-0104 for good cause shown. The extension request comes from two issues: local permitting delays and the utility review process. The permitting delays with the county stem from a Frederick County zoning ordinance that required the project parcel to be merged with an adjacent residential parcel. This entailed the project negotiating an agreement with 3 co-owners of the property along with the mortgage holder in order to process the merger. This process in total took over a year before the project could begin proceeding through the local permitting process. The project informed staff that it has received site plan approval from the county just last week. The second issue led to delays involved cost estimates from Potomac Edison for interconnection. An interconnection agreement was executed in November 2023 with a cost estimate of $477,900. In October 2024, PE notified the project that upgrade costs were increasing by $1.1 million due to a change in the utility's transmission division rules and standards, along with the fact that more than 1 year had elapsed since the initial estimate. PE indicated that the initial estimate was only valid for 12 months. Staff contacted PE to inquire about this increase, and PE filed a letter confirming everything in the project's filing was accurate. PE explained in the letter that 2.5 years had passed since the initial feasibility study and the revised study that was provided after being notified that the project was moving forward had taken place. PE also indicated that no other large projects will be impacted by granting an extension to this project. Staff finds that there is good cause to grant a waiver of the operational deadline requirement as the project has shown a commitment to moving forward by absorbing additional costs and overcoming substantial obstacles along the way. Construction is anticipated to begin this month, thus preserving eligibility for the investment tax credit. Thank you, and I'm available for questions.
Questions for staff? Commissioner Linton.
Thank you, Mr. Chairman. Good morning. First, I wanted to give you an opportunity to respond on behalf of staff to the letter from PE, which obviously, as you summarized the letter, but I didn't know if you had any comments about it.
I have no additional comments. Appreciate that they can agree on the timeline of events and that the rules and standards they indicated are applying to every single project, not just this project.
Yeah, I think that's also important. Are you able to give us any insight about the change in these rules and standards? Was staff aware that this process was ongoing and was going to happen? Or do you know if any of the developers were made aware of that?
This is the first staff has heard of this change.
Okay. I know we received a letter from Potomac Edison, so Mr. Chairman, I know hopefully it's not out of line. I just wanted to know if there was anyone here from Potomac Edison. I did have some questions for them.
Yeah, I think we'll get to them. So.
Okay. Thank you. Then I will end my questions at that point. I'd like to thank staff for taking the opportunity to reaching out to Potomac Edison and getting some additional information for the commission. Thank you.
You're welcome.
Any other questions for staff? All right. Actually, so I assume power plant is okay with this?
Yes, Your Honor, it's under 3 megawatts, and so we did not.
Oh, I see. Okay, right. So anybody here from Potomac Edison who can opine on the letter they sent? Interesting. All right. Well, since maybe we'll rely on you, so we'll turn to the applicant then.
Good morning, Mr. Chairman and Commissioners. Yeah, I thank you, Max Cook, on behalf of Emmitsburg Kiln Solar LLC. I'm also joined by Mr. Greg Warner with the developer. Commissioners, we've reviewed staff and Potomac Edison's filings. We have nothing further to add. Commissioners, I will add that I believe on an email with Mr. Scher and myself, Potomac Edison's counsel indicated that they were not taking a position on the extension beyond what they provided, and I do not believe anyone was attending today's hearing. But that's all the information I have with respect to their attendance. And here to answer any questions from the commission.
Right. So why don't you try your questions?
I'll try my questions. Thank
we'll
you.
see where we get.
So I guess first off, I will say that I'm not opposed to the waiver request. So everybody's on the same page there. I am concerned about the increase in cost to the developer. And so I was hoping that someone from Potomac Edison would be here to further explain what happened. I appreciate and I'm thankful that you received your zoning waiver from Frederick County. And it appears, though, that in your letter, and staff confirmed this with the company, that the increase in cost was a direct reason for a delay in the project. And you cited to it. The company had knowledge of it, but we don't have anyone here to explain what happened. So I guess let me ask this first question. Staff noted that it was an increase by 1.1 million. So can you tell me what the actual cost is now? Is it 1.1 million plus the 477,000, or is it?
The cost is now 1.59 million, so it was by 1.1 million.
All right. So my lawyer math, I thought it went up by a certain percentage, and I was off. Were you made aware that this cost existed first off? I guess you knew it existed, but were you made aware that it could increase at some point? And if so, were you made aware that it could increase to this extent?
Good morning, Commissioners. My name is Greg Werner. I'm Business Development Manager with Nexamp and the lead project developer for Emmitsburg Kiln Solar. No, to answer your question, we were not made aware of anything in advance by Potomac Edison. As stated in the letter, the existing cost estimate and the preliminary approval had been outstanding, had been issued, I think, in February of 22. So it was a little over 2 years that it had been outstanding. But then, without any sort of forewarning, we received in October of 2024 the updated cost estimate that established a new requirement for a 3VO protection equipment at the substation, which was the main driver of the cost increase. We did not receive any advance warning about that transmission standards were changing or that any other costs might be changing at any time.
Okay, so, and I'll note that in the letter, the company, and staff can correct me if I'm incorrect in the summary, but my understanding is that PE indicated that these costs were applicable to every project, not just to this one. Is that accurate?
I know that the company, PE, indicated that their transmission division rules and standards applies to everyone. I don't think every project would require the same type of upgrade, this 3VO requirement.
Okay.
I think that's project specific.
Okay. All right, so something has changed regarding these transmission division rules and standards. For this particular project, it resulted in an increase of over $1 million for the project. I guess at this point, until somebody shows up with another waiver request, we won't know what the impacts are on other projects, assuming they need a waiver and show up at all. They might just do as you did and just assume the cost. All right, well, I won't go on a soapbox about this, but you know, I do have a concern that this is impacting other solar projects, you know, at a time when we need to get as much generation on the grid as possible. As I said, I'm not opposed to the waiver, but I do think there's an issue here that we need to take a deeper look at. So thank you for answering my questions. Thank you, Mr. Chairman.
Okay, so I'm going to continue on with the line of questioning. And I guess, is there some way that we can get information from the company about this change in policy, and to the extent that there are additional costs that are being imposed on solar developers? Is there any way that we can get that information? Because they're not here today, so we can't ask them, and we can't ask them to get the information.
I would be happy to reach out to Potomac Edison and inquire if it's possible that they shared their division rules and standards.
Okay, so if you can get that information and also determine what other solar developers have had these costs imposed on them, because it may just be, as Commissioner Linton suggested, that they're just willing to eat it because they want to get the project sort of up and going, and we don't want that. Because you know, the last thing we want is a project that actually whose economics fail because they have this additional $1 million imposed on them. So that we don't want that to happen. And so if you can go out and try to get that information and report back to us.
I can do that.
Okay, thank you.
Anybody else? So, actually, the question I have is this zoning situation you had to deal with, which apparently, I guess, caused the delay, which I guess then caused the increase in transmission. What exactly were you required to do, and why did the county want you to do that?
Thank you, Mr. Chairman. Yeah, and my client, Mr. Warner, can elaborate further. My understanding is this is related to the county's, they have a requirement, Frederick County, with respect to an accessory use requirement for solar. And I believe that led to, when we submitted our initial site plan, to the county for review, they indicated that certain parcels needed to be merged in order for it to adhere to their local zoning. But I'm going to defer to Mr. Warner to elaborate further.
Yeah, that's correct. So essentially, the previous county code, which has actually been superseded now by the Renewable Energy Certainty Act, but it required that solar projects were allowed as an accessory use on agricultural parcels, and the parcel that we were on did not have any other structures on it. We submitted our first site plan to the county and didn't receive any feedback that there was any problem with the application. Several months later, when they had inspected our application closer, they decided that because there was no structure on the property, we were not an accessory use. We were therefore the primary use. I won't get into the whole interpretation, but there was a disagreement or a misunderstanding about that, and we proposed that what if we merged these three parcels that had the house on it as well, merged them into a single parcel. Would that satisfy the county's request? Zoning ordinance, they said that it would, and so then we started the three-parcel merger process, which took about a year to complete.
Okay, I think now I get it. All right. Okay, with that, I move we grant a waiver of the operational deadline for the company's solar project until February 28, 2027. Commissioner McLean?
Aye.
Commissioner Linton?
Aye.
Commissioner Suchman?
Aye.
Commissioner Barve?
Aye.
I vote aye.
Item number 7 is from Washington Gas Light Company. It's revised calendar year 2025 STRIDE project list.
Excuse me, Madam Executive Secretary Ruthie Herman for staff. Could we ask you to read items 7 and 8 together? Thank you.
No problem. Also calling item number 8 from Washington Gas Light Company. It's STRIDE 2025 semi-annual report reflecting data through June 30th of 2025.
Good morning, Chair Hoover and members of the Commission staff presents. Tanika Alexander of the Accounting Investigation Division, Evan Thomas of the Telecommunication, Gas and Water Division, and me, Neguse Tesfaye of the Engineering Division. On August 1st, 2025, Washington Gas filed its calendar year 2025 semi-annual STRIDE status report, and the company's revised calendar year 2025 STRIDE project list regarding its calendar year 2025 STRIDE projects which were approved by the Commission on December 18, 2024. The company, through its second revised 2025 STRIDE project list, has requested to remove 52 distribution projects from the calendar year 2025 project list. And Washington Gas reported these projects are closed during the company's calendar year 2024 reconciliation filing. However, 27 of the 52 STRIDE projects had a recorded cost of $57,244 paid for paving and material costs related to the works in the calendar year 2025. Washington Gas provided the results of the calendar year 2025 STRIDE distribution projects as of June 30, 2025, as shown in Table 2 on page 6. The company remediated or replaced 754 services of the planned 2,169, that's about 35%, installed a total of 1.4 miles of mains versus 3.1 miles planned for replacement, that's about 45%, and retired 1.1 mile of mains from the system of planned 3.6 miles, That's about 30% of the calendar year 2025. As noted in the staff's comment, staff conducted discovery and evaluated the company's 2 filings. Staff recommend that the Commission note the company's 2025 semi-annual STRIDE status report and the company's revised 2025 STRIDE project list and approve only the removal of 25 distribution projects from the calendar year 2025 STRIDE project list as filed in Exhibit 1. The company is not proposing to revise the existing surcharge currently. The staff are available to answer any question you may have on this matter, and thank you.
Any questions? Commissioner McLean.
Good morning, sir.
Good morning.
What is staff's position on OPC's request to have another look at WGL's STRIDE plan?
Let me leave.
Good morning, Ruthie Herman on behalf of staff. Thank you, Commissioner. So staff reviewed OPC's letter. Already existing in statute was the clause, Commission may review a previously approved plan. That was already in statute. At this point, our response is that staff, Mr. Tesfaye and team, have reviewed the filing, and they recommend that the Commission approve it so that work can continue without a delay and contractors not be laid off.
So is that a no, you don't think we should look at it?
Correct.
Okay.
Yeah, thank you.
Thank you.
Anybody else? Well, actually, so I got a follow-up question. I mean,
Yes, sir.
and I'm maybe paraphrasing them, and I'll give them a chance in a second, but it strikes me that the upshot of their request is the change that happened last session regarding the STRIDE law, and so their view is that this current plan doesn't comply with the changes made in the statute. Now, is it staff's opinion that it does comply with the statute, or?
Thank you, Commissioner Hoover. I don't have an answer for that. What my earlier response was is whether it should be reviewed or not. And there may be an additional legal analysis that we should provide to you to answer that question. And I wonder if we can leave it at that for now and follow up with a memo to the Commission, if that would be acceptable.
Okay, all right. Commissioner Sussman.
So I guess I was okay when you said that you didn't have a position, but if you can't respond to the question about whether it's in compliance, then I don't know that we can approve it. I mean, unless I'm missing something.
Yes, I'm sorry, and
No,
it's not
that's
that we
okay.
don't have a position. Staff and Mr. Tesfaye and team reviewed the plans, and under what was approved in the case in 9708, it's compliant, and they recommend it go forward. We recommend that the work that's planned, contractors have been engaged, that no one be laid off, that it proceed, so that there's not so that work continues.
Right, but now we have a change in statute. So I guess the question is, and I'm not saying that I'm not opining on what on how we should move forward. I'm seeking counsel from you. I'm just concerned that if we don't have a position on, or if there's a possibility that there's a problem in approving the plan because of the change in statute, then I don't know that we can approve the plan. So I'm not, sorry. So Mr. Dean?
Well, the statutory, Michael Dean on behalf of staff, the statutory provision states that the commission may review previously approved STRIDE plans. As I understand it, the main change in the statute is there's additional documentation required that projects are fully justified. That there's additional descriptions of the projects that are required, that there's a new requirement that the gas company demonstrate that is given priority to projects, each project based on risk to the public and cost effectiveness. Another analysis that compares the cost of the replacement projects with alternatives to replacements, such as just repairing leaks instead of replacing the piping. And then a new plan for notification of customers of proposed projects 6 months in advance of construction.
And has this proposal met all of those conditions?
Well, there were not requirements previously.
Okay, the requirements went into effect when?
June 1st. June 1st for new filings.
Okay, and this filing was made,
This filing was made under the existing plan that was previously approved.
okay. So it was not subject to the new conditions?
No, however, the statute does state that the commission can require previously approved plans to comply with the new requirement.
Okay, thank you.
Okay, any other questions for staff? So actually, before I get to you, let me have OPC opine why they want to do it, and then I'll let you respond to all of them, so.
All right. Thank you. Ryan Shu on behalf of the Office of People's Counsel. Thank you, Chair and Commissioners. As regards the particular filing made by WGL, we don't particularly oppose the semi-annual, report essentially, or the project list. We agree with staff's recommendation to keep 27 of the 52 projects that are being removed on because there were some costs that were incurred in 2025. However, the main thrust of our comments are to reiterate what we requested in the gas planning docket 9707 for the commission to review existing STRIDE plans to ensure that they meet the requirements put in by the Next Generation Energy Act, the NGEA, which is in effect in June 1, 2025. As you know, or WGL's STRIDE plan was approved, I believe in 2023 or 4, and then it's going on for 2024 through 2028. So essentially, we have 23 more years, 26, 27, and 28 going forward. And we believe that the commission or this new law was put in place. It was made effective already, and on these going forward years, the commission needs to ensure that the law is being followed. And while the WGL's current plan wasn't approved under that law, we're still on a prospective basis going forward with there's 3 more years in this STRIDE plan, and the commission needs to review WGL STRIDE plan, also BGE's, but that's another matter. But it needs to review WGL STRIDE plan to ensure that it complies with the NGEA that's now in effect, which has a number of requirements. I won't list them all, but essentially some such as ensuring that they review or have estimated costs, they're reasonable, prudent, and that they're considering alternative replacements. There's numerous changes to the law that impose new requirements on STRIDE plans that weren't, that WGL's plan currently doesn't meet it, understandably, because it was put in place before that law was in effect, but the law is now in effect, and we have 3 more years going forward. And so we believe that the commission needs to review the WGL STRIDE plan to make sure it complies with the law now. Thank you.
Mr. Barbe.
Thank you, Mr. Chairman. So, okay, for me to understand this, you are saying that the new provisions of the Next Generation Energy Act are to be applied prospectively to items that have not, where an expenditure has not yet taken place, that it's purely prospective, and that anything that was where the expenditure began before June 1st, that you don't want us to review.
Yeah.
Is that your position?
Yes, correct.
Okay, thank you.
Anybody else? Okay, so let me turn to WGL.
Thank you, Mr. Chair and Commissioner. Spencer Nichols on behalf of Washington Gas. At the risk of being repetitive, we agree with OPC and staff's footnote 1 in particular in its buck sheet, that none of the revisions to the STRIDE statute have an effect on the instant matter, which is simply a STRIDE report on what the company accomplished in the first half of this year, and a regular routine request to adjust the project list, which has happened in the last decade every time the company submits its semi-annual report. So with respect to OPC's letter in this case, it really has nothing to do with this particular admin agenda item. And OPC did, as Mr. Hsu mentioned, file an identical request as part of the 9707 proceeding. And to the extent there are legal questions about whether the commission can and should revisit the company's current STRIDE 3 plan, which is a 5-year plan that Mr. Hsu correctly said started in 2024, I think that's the appropriate place to get into that legal discussion. So, and with that, we just thank staff for its review in this particular project or this particular filing. We ask the Commission note the semi-annual report and approve the adjustment to the project list.
Question for WGL. Commissioner Barbe.
So let me ask you the same question I put to OPC. I mean, is your view that the application of the Next Generation Energy Act applies only prospectively to changes after June 1st and expenditures after June 1st?
I can't give you a definitive legal conclusion, Commissioner Barve, but I'll leave that to your capable legal advisors. But I can say for certainty, and I'm sure they would agree, the statute as written does not specifically apply retroactively, and the statute specifically referenced STRIDE plans, which is a 5-year event of which Mr. Hsu mentioned we're only in year 2.
Yeah, we're definitely going to need to have some have legal beagles look at this. I'm not sure in my mind what is prospective and not prospective. Maybe there's a simple answer. I just don't have it right now in my head. Thank you, Mr. Chairman.
Anybody else? So staff alluded to the idea that if we didn't take action today, that it was going to hold up some of the projects or stop some of the work. I mean, what's the status of that situation?
You'd have to ask staff about that one, Commissioner. I can say I wasn't quite following that. This is just our report on our performance.
Because I guess, my thought is that we might take this under advisement, since this is the first time we're sort of looking at this situation, just to sort of set the rules of the road, not only for you, but also BG&E and Columbia. But, if it's going to cause some undue delay in the work you're doing, that's something else we have to kind of figure out. So.
Well, certainly if the commission, and I would strongly argue this is not the appropriate procedure to issue an order stopping STRIDE work or to Washington Gas. But to the extent that the commission unilaterally did that or did that without outside of the 9707 proceeding, then yes, in that case, that would be a major disruption, as staff described.
So but just sort of understanding what your position is, this is simply a providing you with a list of what you're doing. So if we took it under advisement, it's not going to have an impact on the projects that you are currently working on. You're not asking for approval of anything.
I would definitely ask staff counsel to weigh in as well, but with respect to our semi-annual report concerning the projects we've completed in the first half of 2025, that staff is just recommending, and we agree that you note the filing. which
Right,
is
that's what I'm
that
seeing, is just it's ticking a box. You're not asking for approval, and because of that, to the extent we take this under advisement, because I'm a little wishy on sort of where things are, so I just want to make sure that moving forward with a new provision in place, we're not doing something that is unintentional. So it sounds like to the extent we take it back, make sure that we're dotting all our i's and crossing all our t's. It's not going to have an impact on your projects.
With respect to the semi-annual report, what we're really asking at its basic level is just for the commission to recognize that we were required to file a report, and we did.
Okay.
Yeah, I understand. So, all right. So we're actually going to take items 7 and 8 under advisement, and we'll get something out relatively shortly. So.
The next item on today's agenda is item number 12, which is from Utilize LLC. It's request to serve commercial customers only.
Yeah, no, I think that one's fine. So.
No, she said
Yeah. Right. Yeah.
Did that change?
No. I mean, it's just that's what a lot of these guys have done.
She's doing a portion, this is residential. I'm just confused about what.
Good morning, Chair and Commissioners. Andrew Schlicht on the behalf of staff. On July 24th, 2025, Utilize LLC, an entity currently in possession of an electric broker license, filed a request with the Commission to no longer be authorized to serve residential customers. In staff's review, we found the company to be in good standing with SDAT and to be in possession of an active bond. As such, staff recommends the Commission approve the removal of residential permission from the license, and staff is available for questions.
Any questions?
Thank you, Mr. Chairman. My name is Tom Schmidt. I'm here on behalf of Utilize LLC. First of all, obviously, with no objection, we'd ask that you approve that change to the existing license. I'm a little confused and taken aback why item number 11 and maybe 13 were pulled from the agenda for Utilize Services, which is a similar request except to a pending application as opposed to an existing license.
Well, I think that was done at the request of our staff, so I'll let them respond.
Thank you, Ruthie Herman on behalf of staff. So we looked at the commission's website this morning, and for some reason, there was the buck sheet that Mr. Schlick prepared didn't show up. And so we asked the commission to defer the items just to be totally transparent. And we're sorry for inconveniencing the company.
We flew up from Houston today to be here for this and got no notice until this morning when they announced it publicly.
It's here.
All right. Well, since they're here, and I guess they're the ones that would be most affected by this, I mean, are you prepared to go ahead and deal with 11 and 13?
That's up to you, Mr. Chair. If you want us to, we can.
Okay.
Mr. Schlick can give a verbal description of what.
Okay, so I'm confused because I actually have. I mean, I'm seeing the buck sheet, and are those the incorrect buck sheets?
When Mr. Schlicht and I looked at the website this morning, the buck sheets from 2023 appeared. Staff prepared a supplemental buck sheet.
Oh, I see.
Dated 2025, and for some reason there may have been a website glitch or something. We don't know, but when we noticed it this morning, we contacted the commission, and but yeah.
Okay, so I'm prepared to rule on the 2023 because I actually had reviewed those and didn't look at the date.
Sure, and there's no way you could have remembered. That was right. Those were reviewed at an admin in 2023 in November. But whatever the commission decides, of course, we can give a verbal, whatever you're comfortable with. But the matter is different. So when the matter that was reviewed in 2023, that's the subject of that buck sheet, was licensure for broker licensure for residential customers and commercial industrial. The company updated their request a few months ago to just be asking for a broker license for commercial, to apply to commercial industrial customers. And so the recommendation is slightly different. And then there are some additional facts that EAP put together.
So item number 11 has to do with commercial customers?
Both 11 and 13 are utilize services request to get licensed as a broker. One of them is for
What's item 11?
13 the same company. 11, 13 the same company. Right. Okay, I'm sorry. Could I ask you, say the question again? I didn't hear.
Okay,
Sorry.
so item 11, it doesn't have to do with residential customers?
11 and 13 both have to do with commercial industrial customers.
Okay.
And what we were just talking about is that, and what Mr. Schlick was going to explain, had 11 and 13 been on the agenda, is that number 12 is a different company. There's Utilize LLC. And if you'd like, I can get Mr. Schlick can come back and start talking about that with you.
No, I'm mostly just trying to get, I have residential, so it's not residential, it's C&I?
Right.
Okay.
And when the November 2023 request was for residential and C&I to get licensed as a broker.
Okay, I'm just looking at item number 11 has to do with C&I customers and a broker license?
Yep, a broker license to serve C&I only.
Okay, number 13 is what?
A broker license. I think one is gas and one is electric. I don't know right in front of me
Okay.
which one is which, but they're both to get licensed as brokers
Okay.
to serve C&I only.
Okay.
All right, well, since they're actually here, why don't we go ahead and pursue on all three of them?
Well, good morning, Chair and Commissioners. Andrew Schlicht on behalf of staff. We want to begin by making a clear distinction here between the items that are before the Commission. So items 11 and 13 are concerning Utilized Services, LLC. They have a pending set of applications to serve as an electric and natural gas broker in Maryland. Utilize LLC currently has an electric broker application, currently serves electric broker customers. They currently have a license. These companies are two separate entities, but they have the same corporate leadership, website, and headquarters address. When it comes to the company that currently has a license to operate, they are requesting to remove residential permission from their existing license. That's Utilize LLC. The company that is seeking to become licensed to serve in Maryland, seeking to become a licensed electric and natural gas broker, Utilize Services, LLC. They filed their initial applications back in 2023. Later that same year, the Commission had deferred making a decision requesting that the company coordinate with staff, OPC, and the Consumer Affairs Division to work out some issues and concerns that had been raised with the marketing material and communications that were available on the company's website. Staff received a updated supplemental set of information from Utilize Services on these pending applications. These pending applications are now seeking to no longer serve residential customers and simply go forward as a C&I broker. Staff, however, does not change its recommendation to continue seeking denial of these applications, of these licenses. Simply stated, the company has not fully addressed the concerns and the requirements that were set forth by the Commission from late 2023. The Commission set forward saying, we would like for the company to work with CAD, to work with OPC, to work with staff, and address the marketing concerns that have been raised at the meeting. These concerns have not been fully addressed. If we visit the website for the company, we see that some of these changes are almost superficial. Some of the concerns that staff had raised earlier were for claims such as savings. There was a button, for instance, on the company website selecting, stating start saving now. That button is no longer available on the homepage of the website. However, taking one step further into the company's website, that same wording appears. And these concerns that staff has raised with some of the verbiage, some of the terminology that is used on the website has disappeared from the homepage, but reappear as one ventures forth deeper into the website. As such, since the concerns of the commission and staff have not been adequately addressed, staff retains its recommendation that the applications be denied, and staff is available for questions.
Okay, any questions for staff? Commissioner Sussman.
So, Mr. Schlick, have you shared the concerns that you have with the company?
The concerns were issued in the staff's comments. They were presented to the company, and these were ultimately seen as things that the company were to ultimately address.
Okay, and then their response was that they were taking care of it, or they just had no response?
We received one communication from the company, but we didn't receive anything since the 2023 administrative meeting.
Okay, and are they aware that you're recommending that their request for a broker license be denied?
We do not believe so. This was to be in staff's comments that were to be published and ended up not actually making it to the website.
Okay, so they've never received the buck sheet.
That is our understanding.
Okay, all right, thank you.
Anybody else? Commissioner McLean.
Sir, is the only reason we're here is because they updated their application?
Correct. That is correct.
Okay, so it's just been sitting out there for 2+ years?
We did receive communication from the company, and staff did coordinate with CAD and OPC, but the application has, for the most part, simply been sitting.
The company's application from 2023 had been deferred, and we had some brief communication with the company as to whether they wanted to continue or not. And then we heard from them, the commission heard from them, I believe in July, I don't have it in front of me, that they wanted to revise their request and amend back down to CNI.
All right, thank you.
Commissioner Sussman.
And Ms. Herman, when you received word from them that they wanted to revise their application, did you communicate with them that they had still not addressed the concerns that you had back from 2023?
We did not, no.
Okay, thank you.
Okay, actually, let me turn to OPC because they did file letters in this, so let me hear from them and then we'll turn to the company.
Good morning, Chair Hoover. Good morning, commissioners. Portia Odro for OPC. I think that we support staff's recommendation for Utilize LLC. That's the one that already has a license and is operating now. We support staff's recommendation that they should be granted their request to remove the company's electric supplier license to serve residential customers, provided that the company will be required to maintain its bond with its commercial license. And for Utilize services, we're informed this morning that there was a mishap, but OPC still relies on the comments that was filed on November 6, 2023, in support of staff's recommendation to deny the company's request for license to operate in Maryland, as OPC shares similar concerns from staff's comment that there were multiple scenarios in which the marketing materials appeared to be deceptive and false in violation of state law, and nothing was done up to now. So just trying to change it to just commercial and industrial does not change the fact that they did not avail themselves for this matter to be resolved. And with that, we are available for any questions.
Any questions for Okay, so let me turn to.
Thank you. So I'm going to kind of work backwards with the most recent question of why 2 years? Why are we here? So the company Utilized Services applied for a license for primarily for consumer, but also for commercial and industrial. We came to a hearing. They expressed concerns at the last minute that the website was confusing or perhaps deceptive. We all agreed, commission, everybody, to adjourn the decision for us to go back and change the website. We made massive overhaul changes to the websites. On multiple occasions, we communicated that back to staff. Never heard a word back. I think there was one back and forth where we made a change. They didn't like it. We fixed it further, but then there were substantial additional changes after that fact. Since that time, we've not heard a peep to this minute that they still object to anything on those websites. To sandbag here, even if they had filed a document expressing that today, it would have been late. They should have come back to us and expressed concerns, number one. The reason for the delay, the reason we never came back and pushed for the license to be approved is in the meantime, the state of Maryland changed rules for consumer provision of broker and electricity services, which made us step back and say, can we operate under the new regime? And for, I don't know, maybe it was as long as a year's time, we weren't sure if we were going to be able to continue helping residential customers. So we couldn't move forward or pull the license until we sort of got clarity on that. And it wasn't until this past spring that clarity became, we were sort of our last partners after lots of brainstorming sessions said, look, there's just not a way we can help your customers. So we said, okay, let's go ahead and pull the residential license for both Utilize LLC and for the application for Utilize Services. I think it's important to note all of the only objection, there's no objection to the team, there's no objection to the skill, there's no objection to the operation, none of that. The only objection is on the basis of consumer protection, which was we think consumers who are not educated won't be able to tell the difference in what your marketing says, and they may be tricked or fooled by something that's on your website. Now that that's removed as a problem, I don't see any legitimate objection to the Utilized Services application being approved because we're only doing business with businesses and industrial companies. I think it's also important to recognize we're here in the state of Maryland, but this company operates in all 50 states, offering bill reduction services for tens of thousands of customers. I think the current count is over 70,000 active customers nationwide. We operate in the electricity space in every deregulated state except for Connecticut, providing this same service with either Utilize LLC or Utilize Services LLC with the same marketing materials, the same, not a single complaint. There are no customers saying, hey, you promised me savings and I didn't get it. Because what happens in reality is some customers come to us, they see the marketing, hey, listen, you're offering to save me money on my electric bill. We look at their account and say, hey, you know what, we can't get you any savings. So we don't perform any services. We're not charging them any money. That's a free sort of look at their account that we offer to every customer. So the people who may not have achieved savings from Utilize also didn't engage us, didn't pay us, weren't tricked or fooled in any way. There's no harm. Therefore, there's no complaints. We have a 100% customer satisfaction guarantee. If there's some mistake is made, and occasionally something goes wrong, someone gets billed for something, they moved and they didn't tell us, so we billed them when we should have, all that gets corrected, the money gets refunded, there's never been a complaint. So to say that we're fooling people, deceiving people, is just not realistic. What the website says is, look, you engage us, if we can save you money, we will charge you fees. In many cases, we don't charge any fee because we receive a commission from the electric company that we provide the customer to, particularly in the commercial area. And in any case where we can't save them money, we refund any fees, if over a period of time we're not able to achieve a savings. So, all of this conversation, I get it. If you look at it in a vacuum and say, well, we're going to save you money. It may seem at first blush that I'm promising something I may not be able to deliver. But the reality is, if I can't deliver it, then you don't become my customer. So it's not like I'm having you hire me on the promise of a savings that I'm not delivering. It's come talk to us and see if we can save you money, and we guarantee you you'll save money. So in other words, you sign up, we save you $100, but then next year something changes, we'll refund your fees if we're no longer able to continue. So again, going back to, there's never been a single complaint for either one of these companies. There's nobody being cheated or misled or anything else. And most importantly, going forward, all we're looking to do is serve businesses and commercial and industrial, and so there is no consumer protection component to this after today.
Okay, Commissioner Barbe.
Well, I was just going to ask if Mr. Chairman, if a 1-week pause in this instance is appropriate so that the staff and the company and OPC can discuss the matter. I don't feel comfortable moving forward at this moment.
Oh, thank you. Ruthie Herman again for staff. I think that the company might be a little confused. I sent an email on to Ms. Aniston, who was the representative we were dealing with. I'll give you the date and time. Let's see. Well, it was probably in January of 2025, because they're saying Thursday, January 23rd, and this is in the buck sheet that the website was supposed to show you. It has my emails in the back, attachment B. In response to my email, Ms. Aniston replies to me on Thursday, January 23rd at 11:27 a.m. Dear Mrs. Herman, thank you very much for your follow-up. We'll discuss this internally and reach out to Mr. Mosier, Kevin Mosier, the head of EAP, for further information. So we don't have dozens of emails from them after the November 23rd hearing. I reached out to them to tell them that there's been we haven't heard from you. We don't know that you've changed your website, but there's been a change of law in Maryland. We want you to know. So we're not sure what those dozens of emails are.
All right, well.
Yeah, thank you.
So let's do this.
Sure.
I mean, one of the main issues when it came to SB1 was this issue about commercial and industrial customers. And that all of them showed up and said, you know what, we're perfectly happy with the way this system works. We don't need any extra protection, so we want to be exempted out of SB1. And they were. And so I guess what I'd like to suggest is that staff, OPC, and the company get together and see if we can come to some agreement as to what licenses they are seeking, and see if we can work out a process where we can approve their license for commercial and industrial customers. And if the two of you come to an agreement, you don't need to come back here. Okay. We'll just deal with it.
I appreciate that.
And yeah, well, I understand that. So, so that's what we'll do regarding items 11 and 13. Item 12, which is your current license, I move that we grant the request to remove the permission on the company's electricity supplier license to serve residential customers. Commissioner McLean.
Aye.
Commissioner Litton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
I vote aye.
Thank you.
Okay.
Thank you very much.
The last item on today's agenda is item number 14 from Securus Technologies LLC. It's request to transfer of control of Securus Technologies LLC to SCRS Intermediate Holding Corporation and planned participation of Securus Technologies LLC in certain financing arrangements.
Good morning, Chair and Commissioners. Kenneth Albert on behalf of staff. This item addresses new financing and the acquisition of direct control of a Maryland telecommunications company, I'll refer to it as a telco, named Securus Technologies LLC. I'll refer to them as Securus. The dispute here focuses on the transfer of ultimate ownership of Securus from SCRS Holding Corporation to SCRS Intermediate Holding Corporation. And I'll refer, there's going to be a bunch of terms here, just to make it a little more clear. The focus is really on the SCRS Intermediate Holding Corporation, which I'll refer to as Holding Corp. Both Holding Corp and SCRS Holding Corporation are currently indirect owners of Securus, and Holding Corp is a public traded corporation. As part of the transaction, the corporate stock of SCRS Holding Corp will be eliminated, and SCRS Intermediate Holding Corporation, Holding Corp I'll call them, will issue new stock. A group of lenders will acquire the new stock. The transaction essentially, it involves the transfer of corporate stock of Holding Corp to the lenders, who will become the new ultimate owners. Significant here is that Holding Corp is a Delaware holding company and does not operate in Maryland. As a result, the transaction does not involve the acquisition of the corporate stock of a public service company that operates in Maryland, and this means that the authorization is not needed under the terms of PUA 6101C3. Also, because Holding Corp does not operate in Maryland, commission authorization is not needed under PUA 6101C4, which applies to acquisition of more than 10% of the corporate stock of a public service company that operates in Maryland. Now, in its comments, OPC asserts that Holding Corp is a holding company, and because they're a holding company and the indirect owner of Securus, the Commission should, in applying 6101C3, impute to Holding Corp the Maryland telco operations of Securus. Essentially, OPC would deem the Maryland corporations of Securus to be the Maryland operations of Holding Corp for the purpose of applying 6101C3. The impact of this would be that the Commission would have jurisdiction over the transaction under 6101C3, which would mean the applicants would need Commission authorization of the transaction. And when I say transaction, I mean the change in ownership. However, as explained in staff's buck sheet, imputing jurisdiction over a holding company that does not operate in Maryland is inconsistent with the language of PUA 6101C3. Now, we appreciate this is a classic case of a tension between the express words of a statute and what may be a broader policy goal that OPC alludes to. And certainly by this imputing, we would expand the Commission's jurisdiction in this situation. But staff looked at this, and frankly, we've been somewhat inconsistent on this in the past, so we gave it a hard look in this instance and decided that we would think the more appropriate approach is to go with the direct language of the statute. Just a couple other issues coming up. Parties have questioned the management of the Securus going forward with this transaction. In an August 19 filing, Securus did give information on the management that would be going forward with the company if the transaction is approved, and we think the management, it reflects the fact that the management has extensive experience. And I would note there have been no complaints filed with this commission against Securus. In their comments, OPC cites comments by an organization called Worth Rises that alleges that Securus has imposed excessive rates in connection with the prison telco services that Securus provides throughout the country. And they are, in fact, a leading provider of prison telco services. Staff recognizes a serious concern, and of course you're dealing with, as Worth Rises pointed out, a very vulnerable population. They're incarcerated. The concerns is that they be able to have adequate contact with their families and neighbors while they're incarcerated. Our concern is that we don't think this is the appropriate forum for that. We think in this situation it's focusing on a transaction, financing, and the transfer of control, and we think that the appropriate forum for those concerns would be to file a complaint against Securus. And we would note that a threshold issue in any complaint involving prison telco services would be whether this would be an issue that is under the jurisdiction of the Federal Communications Commission, the FCC, or this commission. There's been tension between the two. FCC did a 2024 decision, imposed a whole bunch of restrictions on rates charged by prison telco companies, so they have been active in this sphere, but we don't need to address that here. But we just want to note that would be a threshold question in connection with any complaints. To sum up, staff believes that the transaction and the financing do not need authorization. Therefore, we recommend that the Commission note the financing and transaction, and again, concerns regarding the practices of Securus as a prison telco operator should be addressed, if at all, in a complaint proceeding. Thank you.
Okay.
Morning,
Well,
Chair.
actually, any questions for staff? Okay, go ahead.
Good morning, Chairman Hoover, Commissioners. Mark Shebus for the Office of People's Counsel. I want to get to the specific issues that Mr. Albert described, and he accurately characterized OPC's position. I think essentially it comes down to the meaning of the phrase operates in Maryland and whether SCRS Intermediate HC is a company that operates in Maryland. But before I get there, I want to just pull back a second and give an overview of prison telecom law and issues. Essentially what this matter is about the adequacy and affordability and fairness of telecommunications services to people incarcerated in Maryland jails and prisons. Prison telecom is a competitive business in that different companies compete against each other to enter into contracts with jails and prisons to provide telecommunication services. But once that contract is issued, the people incarcerated in those facilities have no choice but to take service from the selected company. That's why, and so it's a monopoly, and that's why prison telecom companies are covered in the definition of telephone company in the public utility article. The rates charged by telephone companies that serve correctional facilities are regulated in the first instance by the Federal Communications Commission. And that's true now of both interstate and intrastate rates. It used to be only interstate, but the federal Martha Wright Reed Act of 2022 expanded federal authority to include intrastate rates as well. That law preempts this commission from allowing rates that are higher than what are set by the FCC, but does allow the commission to set rates lower than what the FCC has established. And I believe California has done that in the past. In Maryland, rate setting for telephone companies doesn't happen through rate cases in the way it does for electric companies, gas companies, and some water companies. Rather, Maryland generally uses an alternative form of regulation established under Section 4301 of the Public Utility Article to regulate telephone companies. And practically what that means is the Commission's regulation takes the form of reviewing tariffs and proposed changes to tariffs, and reviewing ownership and financing transactions. So this type of transaction is one of the relatively rare opportunities the Commission has to look at the operations of a telephone company, especially one that is going to undergo a significant change in ownership that could affect the service provided to the people incarcerated in the facilities. I won't repeat what Mr. Albert said. He accurately characterized the transaction. OPC does not dispute that the financing arrangement that the companies propose is exempt from Commission review. The issue here is whether the Commission has jurisdiction over the change in ownership. And essentially, again, it comes down to the question of whether the operations of Securus, the company that directly provides telecommunication services to incarcerated facilities, should be imputed to the holding companies. It's clear under the law that each of the companies in the chain of ownership is to be considered a public service company of the same class as Securus. The question is, should the operation of Securus be imputed as well? There's no law on this. We couldn't find any decision where either the Commission or any other body has interpreted this language. I'll note that the phrase operates in Maryland is different from the phrase used in the Corporation Code, which is doing business in Maryland. And I think if the General Assembly had intended to say doing business in Maryland, it could have used exactly the same language. It did not. The economic substance of the transaction is, as Mr. Albert described, transfer of ultimate control of Securus from one set of owners to another, one holding company to another. If the Commission accepts staff's legal interpretation of the law, it essentially means that any company, any telephone company proposing a change in ownership can simply do it through holding companies established in Delaware and evade any kind of Commission review. We don't think that is consistent with Maryland public policy of oversight of telephone companies, and that's primarily why we think the Commission should reject it. And I think I can stop there. I think that sums up the basis. It is a legal interpretation issue, what the phrase operates in Maryland means. And again, if the commission adopts staff's interpretation, it is essentially relinquishing jurisdiction over transactions of this kind that could have real impacts on Maryland telecommunications customers. In this case, people who have no choice of their telephone company who reside in Maryland correctional facilities. Thank you very much, and I'm happy to answer any questions.
Commissioner Barbe.
I'm making the mistake of asking a question where I don't know the answer. If a company is a Delaware company and it's servicing customers in the state of Maryland, would not Maryland law apply regardless of where the corporation is domiciled?
Mr. Barber, I think that's not clear under the law. I think there's a sort of, under the state's corporation code, there are lots of provisions regarding foreign companies and what it means to do business in Maryland and personal jurisdiction over those companies. Here we're talking about a provision under the Public Utility Article that specifically regards transactions between public service companies and transactions between non-public service companies that are acquiring public service companies. So we just don't think that the statute clearly answers that question.
I mean, I had always thought that it was a broad principle of law that, oh, no, it doesn't. I guess click-wrap agreements are pegged to the law in which the company is domiciled. Okay, thank you, Mr. Chairman. I need to think about this then.
Commissioner McLean.
Good morning, sir. So say we agree with you and we deny it. What then? I mean, are you looking for like a broad brush investigation, or is that kind of the next step?
Well, thank you for the question, Commissioner McLean, and that makes me realize that I didn't discuss the public interest aspect of this, which is essentially why we think the Commission should deny it. There's one question of the jurisdiction over the transaction, another of whether exercising jurisdiction the Commission should approve or deny. We think in this case it would be appropriate for the Commission to deny without prejudice to the companies refiling the application. We think the company should provide more comprehensive information about the ownership, the new ownership structure, and particularly those new owners. The company has discussed in its application 2 of the new capital stock owners of what will become the ultimate parent company, has not disclosed the others who will account for the great majority of the equity in voting shares. The company knows the applicants know who those parties are, but they have not disclosed them. We think that should be part of the public record of the case. And we think there should also be more comprehensive information about the new plan for operating the company. The company's made only conclusory statements about how their new structure and operations will serve the public interest. On the other hand, Worth Rises, and I see they're on the call today, has raised some pretty significant questions about what that new type of operations will be going forward. We think effectively that has shifted the burden to the companies to say more about how they're going to run these operations. They have not done that. They have not provided any new substantive information in response to the comments filed by Worth Rises or the comments filed by OPC. So we believe that denial without prejudice is the appropriate step here.
Okay, thank you, sir.
Anybody else? All right, so has OPC gotten any complaints from the residents of these correctional facilities regarding these telecommunication services? Not just this one, but any of them?
I am not sure, Chairman Hoomer. I did not look into that specific question before this hearing. I can certainly find out.
Okay. Because I guess, staff's view is that the way to fix this, if it's a problem, is for you to file a complaint and sort of, put this in front of us to deal with the substance of it, as opposed to this kind of sideways approach by dealing with this financing arrangement as a way of addressing the issue.
Chairman Hoover, we could certainly do that, and I can look into whether there are complaints, but I don't know that whether there are complaints or not answers the question of whether this is in the public interest. I think the statute requires a scrutiny of the transaction. It's also true that, there could be plenty of issues that don't generate complaints. I don't think that the people incarcerated in these facilities are in a position to file complaints for the most part. Their family members might be, but that depends on their knowing of the processes and routes for channeling complaints.
I understand. Now, I guess the other issue is, I mean, since I've been here, it seems to me we've approved a number of these financing arrangements and have done exactly what, staff's recommending that we do today. So it seems to me there's precedent for us not really taking action other than noticing the filing. So it seems to me this might be a significant change in direction for us to, deny this application or defer it or do anything other than just take notice of it. So
That may be correct, and I want to just clarify, Chairman Hoover. I think you mentioned financing arrangement. I think the issue here is more the change of ownership because they're sort of separate in the applications. That may be true. This may be a departure from the way that the commission and staff have historically looked at these, but we think that what we're advocating here is just correct on the law.
Okay. And then, you may not know this, and if you don't worry about it, but, I mean, are you aware of CAD getting any complaints regarding this type of telecommunications service?
Well, as of 9 a.m. this morning, and I've checked in the past, they said no complaints against Securus. So, yeah, that was obviously when they raised these concerns, one cause. And we appreciate the point Mr. Shibas makes that you're dealing with an inmate population, but there are family members, it's striking that there have been 0 complaints rather than just a small number. So we think that's telling. But again, we still go back to the fact we think this is the wrong forum. We appreciate those concerns, but this is not the right forum.
Chairman Hu, could I add one point? The fact that there have been no complaints under the previous ownership doesn't mean that there may not be operational issues with the new ownership. Again, what we're talking about here is the new ownership. So the non-existence of complaints to CAD and assuming that there have been none to OPC, I don't really think that's a material factor for this decision.
Okay. So, Mr. Collins, I take it you represent, and is this your client who's on the screen?
Yes, thank you, Mr. Chairman and Commissioners. Carville Collins, on behalf of the applicant, Securus Technologies, LLC. Just one introduction. With me today is Clint Arnold. He is Senior Manager of Regulatory Affairs for Aventiv. That's the parent company of the applicant, Securus Technologies, LLC. OPC has made a number of allegations. I'd like to respond to those. There's at least one misstatement. I would like to respond to that as well. But let me first just acknowledge the staff for its comments. We do concur with the views that are contained in that buck sheet. A little bit about the history of transactions of this nature for the benefit of the Commission. This same applicant has come before the Commission on 3 prior occasions since 2013. It's in 2013, let me make sure I have my dates correct. On 3 occasions in 2011, 2013, and 2017 with similar applications for a change of control and an accompanying financing arrangement. And in each of those prior cases, just not that it necessarily applies here to this particular set of facts, but the precedent has always been for the Commission in those 3 prior instances to note the transaction, and they noted both the financing element as well as the change of control. I believe in one of those instances, the Commission actually approved the change of control rather than noted the change of control. But in none of those cases did they launch into an investigation of the kinds of things that OPC has suggested needs to be reviewed here, such as the possibility of future complaints, the quality of the service, or the nature of the service in that there's a single provider and that it is a monopoly service, because the state only procures the service from one provider. So that's I think relevant history here. What OPC is suggesting is completely unprecedented in terms of what the Commission's practice has been on transactions similar to this by this same applicant. In the filing that the company has made and in subsequent data requests submitted in response to questions from both the staff and OPC, so there are data responses to both staff and OPC here. Securus has presented, yes, a somewhat complex transaction, but it can be accurately summarized as a transaction comprised of two parts. There's a change of control, and two, there's a refinancing to be achieved by an exchange of debt. And as OPC has said again here today, I think it's true that all parties are in agreement that the financing part of this transaction meets the statutory criteria for an exemption from Commission review or approval. So that leaves us with just the change of control. And for the reasons set forth in our notice filing and in the supplemental filings that we've made back in June and July, together with the reasons presented by staff in its September 25th comments, we do not believe that a Commission approval is required under the two applicable statutes. That's 5203 and 6101 of the Public Utilities article. Now, in deference to the Commission, Securus has acknowledged in some of their data responses that the Commission may in fact determine that its approval is authorized and necessary on the change of control. And staff has noted this same deference to the Commission in its comments on September 25th. So here's what we would suggest if the Commission determines that that's the route that it would go down. If Commission approval is needed, Securus has directly and fully addressed People's Council's concerns about the disclosure of the identity and role of the management of the new controlling entity. That new controlling entity is SCRS, Intermediate HC. Secondly, and just to make clear what that disclosure was, all of that disclosure was made in writing to OPC, in response to OPC. So that information has been fully provided. Securus has also explained in data responses that none of the lenders in this transaction has or is expected to acquire a 10% or greater interest in a telephone company. There are only two lenders that have a greater than 10% interest in this transaction, and neither one of them has a controlling interest in a telephone company. A final point, again, if the Commission determines that it is to approve the transaction under the applicable statutes rather than simply note the transaction, is that we have directly and fully addressed the public interest considerations of this transaction. OPC seems to suggest that we have not, and that we have not met the public interest test, but we respectfully disagree, and we submit we have met that test. I will not repeat all of those public interest considerations that were presented in our filings and are well summarized by the staff on page 9 of its September 25th comments. But since OPC makes the contention that we failed to show public interest, I would add yet another one that is not already provided to the Commission. Securus is today contractually obligated to deliver its telecommunications services to correctional facilities in Prince George's County and 3 smaller Eastern Shore counties for set time periods as required by contract. Its services in Maryland have attracted no complaints filed with the Office of Attorney General of the state of Maryland or filed with the Public Service Commission. And there are no enforcement actions at the FCC in the past 2 years. I don't know that any of us can predict or have any sense of future complaints, as OPC would like the Commission to consider, but in the past and in recent years, no complaints before this commission, before the Office of Attorney General and its Consumer Protection Division, or at the FCC. This transaction is further in the public interest because it will significantly reduce the financial commitments of Securus, making it a more financially viable company that is better enabled to fulfill its contractual obligations and continue its provision of services to public correctional agencies and facilities in Maryland. These services further provide a valued service to a constituency of nearly 1,400 incarcerated persons and their families. For all these reasons, Mr. Chairman and Commissioners, we urge the Commission to note or, as necessary, approve the transaction. Mr. Arnold and I are available to answer any questions. Thank you.
Okay, any questions for? So, just so I understand how this business operates, so this company has contractual arrangements with the local governments that own the correctional facilities, detention facilities. So, and I think you mentioned Prince George's County and apparently a number of counties on the shore. And I guess my understanding of the arrangement is that they charge the inmates a certain amount for making calls, and the proceeds get split between the company and the correctional facility. Is that, can you verify that that's the way the business operates?
I think I'm going to
Yeah.
ask Mr. Arnold.
Yeah, no, that's fine, sure.
To respond to that. I do not know the answer of the allocation of the revenues when they come in.
Yeah.
Thank you.
Good morning, Commissioners. I'm Lynn Arnold. I'm here representing Securus. And as far as your question goes on that, yes, that money is, some of that money does go to as a commission.
Okay, so in that sense, I mean, the customer is really the detention facility that you have the contract with, not their residents.
The facility is the customer.
Right.
The incarcerated individual is the consumer.
Yeah, I understand that. So, so I guess I'm a little concerned. I mean, not that I have any, casting aspersions on your particular company. This is more about this industry.
Right.
I've sort of had concerns all along about the fact of this sort of mixed incentive, that the correctional facility, if they're getting the money from you, they probably don't care whether or not the service provided to their residents is adequate.
I still think they care, yes.
All right.
They, and as far as the gentleman from OPC said, the incarcerated individual can make a complaint, and so can the friends and family, through the system, the agency, or directly to the FCC.
But not to us.
Yes, they can make a complaint to you.
Okay. All right. Anybody else have any questions? All right. Well, I guess I'm not quite convinced that we actually do have authority to opine on this transaction, other than what we have done in the past, which is note the transaction and the filing. So that's the motion I'll make.
Chairman Hoover, I'll just remind you that we have a representative from Worth Rises on the call who, if the commission would like, I think is prepared to address the public interest issues.
Okay, all right. And if you could identify yourself and then go ahead. So.
Hi, how are you all this morning? For the last 4 or 5 minutes.
Actually, I'm going to need you to either get closer to the mic or speak up so that we can hear you.
Oh, okay. Is this any better?
Oh, not much,
Okay,
but
give me 1 second. I'm going to switch to my audio phone. Just need.
okay, all right.
Is this better?
Yes, that worked great. So go ahead.
Great. Okay, sorry about that, and thank you for your patience. My name is Bianca Tylik. I am the executive director at Worth Rises. We are a national organization that works to end the exploitation of people who are incarcerated and their loved ones. We've been doing this work for over 8 years, and our sort of bread and butter work is in the prison telecom industry, where we've worked really all over the country, not just with legislatures, but also with regulatory agencies at the state and local and federal level. At the FCC, with the California Public Utilities Commissions in New York, and still others. So this is an issue that we're very, very familiar with, including the companies that are all involved. We've been in deep conversation with them over the course of these years, and also agencies. So to start, I just want to affirm the OPC's argument and position on the requirement for an approval here. I think that, there are a few cases that were made. I think even Securus' own counsel acknowledged that there was an approval that was granted in one of the 3 other previous transactions. I think it's important to note that this transaction is nothing like the previous 3 transactions. This transaction of ownership transfer is the result of a default of $1.6 billion in debt. That is not like any of the prior 3, which were natural sort of acquisitions and transitions happen in sort of the regular course of business when private equity does what private equity does. So this particular moment, at which the company has been a distressed asset for over 2 years, I think is incredibly important for the commission to take a deeper look at, and one that is different from prior years. I note that I want to focus on most of my time on sort of this public interest and why it is the right forum. There was a comment made sort of by staff that, this complaints can be issued in other places. This is not a complaint. This is about whether these new owners should be in charge of a public utility in Maryland. And the question here is about these particular new owners, not about prior complaints or former complaints. So I do want to acknowledge, while there may or may not, and I can't contest what staff has said, been complaints in the state of Maryland, there have been 15,000 comments alone about Securus and some of its actions in just the last month before the FCC. Some of those coming from Maryland. I also want to acknowledge that Securus is currently leading the charge in litigation against those 2024 regulations that were mentioned earlier issued by the FCC, and that the Maryland State AG has joined the opposition to Securus and Securus' position in that case before the First Circuit. So it's important to note that even the state of Maryland is taking a position against Securus in other forums. And so right now I want to get back to this particular issue of these owners and why this is something that we really urge the commission to take a look at. We know that there's a conversation about 10% ownership and all of that. It is important to note that the way that they are distinguishing the existing stock and issuing new stock actually means there's a 95% ownership change. 5% of this new holding company will continue to be held by Platinum Equity, which is a private equity firm that currently owns and is looking for the ownership transfer of Securus or event of its holding company. It will only own 5% after that. So while, yes, any one sort of eventual owner or investor, only 2 of which are over 10%, overall, we're talking about a 95% shift in ownership of this company that is a public service company. This company has an incredible history of harm, and that situation is likely to only get worse under a set of owners or investors that came in through this distressed period of time. It is not sort of to anyone's surprise that distressed debt investors are often referred to as vulture investors. They come in at particular moments when companies are vulnerable and seek to exploit sort of those business models and the people and customers, obviously, that are involved. That is who we're talking about. That's who has now acquired this company, because the company didn't essentially go bankrupt overnight. It was over a 2-year period that it ended up defaulting on all this debt. And these harms are not just captured in a complaint before the PSC. They're captured in countless pieces of litigation all over the country that include Marylanders. It's important also to know, I appreciate the counsel on the other side mentioning that none of the major investors that own over 10% of this particular telco or are expecting to currently own more than 10% of the largest other player in this field, GTL. But they didn't say that that's no ownership stake. And there are questions of antitrust there. I import on this particular body, this entire field is a $1.5 billion industry, of which 80% is owned by just two companies. And one of them stands before you that owns roughly 40% of this industry. As these ownership transfers happen, it's incredibly important to get to the bottom of who exactly is going to own this company. And there's been a lot of mention in the different filings about management changing or not changing, there being a board appointed. You know, as they talk about what the harm is going to be, majority of the people on the new board have been priorly involved in this company, including two former CEOs of the company that were there under the moment where the company lied to the FCC under its last ownership transfer in 2017 and was fined by the FCC for misrepresentation during its ownership transfer petition. And I really want to stress that because I don't know how much we can trust what is in their ownership transfer petition when the FCC fined them the last time they tried to do one of these. In any case, I think through all of this, what we really want to just urge is that there are a lot of questions that are left here. By no means, I think, could the council in seriousness say that a public interest assertion was made when literally all it says is we claim that this is in the public interest. And that simply a reduction in debt is going to somehow change that. I want to assert that this company is also asking for authority to increase its debt after this acquisition. So how is that going to change anything, especially when these particular investors are charging 10% over SOFR for the bridge loan? These are incredibly high interest rates, incredibly ruthless investors. This is who we're handing over the company to if this commission doesn't take the important action today of actually deciding that it has the authority to approve this transaction and deny it based on public interest claims. And the reality is, even if you're not prepared today to deny this transaction, you do have the ability to ask for more information. There's just simply not enough here, certainly not enough about the ownership, and not enough about what its impact on public interest is going to be based on the history of this company. So that is what I sort of put before you. And I think there was one question I just want to answer that one of the commissioners raised about what happens if you deny the actual acquisition or this ownership transfer. And I want to assure you that, again, we're working with a duopoly in this field. There are, however, more than a dozen other companies in this space, right? There are a number of things that can happen. There can either be a new owner, they can actually release who these owners are, or you can liquidate a company and hand over bits and pieces of contracts to other experienced providers in this field and create a real market with market competition. So with that, I'll stop. I'm happy to answer any questions, and thank you so much for your time.
So, any questions? Alrighty. So, actually, let me, before I turn to Mr. Collins, so, Mr. Albert, I take it this is all new information to you?
Well, Net Worth had raised in their comments concerns the duopoly, the idea that Securus and another company own 80% of the market, or the current owners. So yeah, we're aware of those concerns. Again, our issue goes more towards the forum. We're not prejudging the merits. We appreciate the concerns about a very vulnerable population, but in the context of a transaction, whereas you're well aware, we typically do note these transactions or do an approval without any kind of conditions. We just think this is not the kind of forum that's set up for the fact gathering and investigation, which would more increase the odds that Worth Rises would get the kind of result they want.
Okay. Mr. Collins.
Mr. Chairman and Commissioners, Carville Collins again for Securus. Thank you for the opportunity to respond. A number of allegations have been presented to the Commission now based on the representative of Worth Rises. I guess I just have a few things to say in response to what I've just heard. The first is, again, what they are suggesting is an investigation or a review or an analysis that is unprecedented here before the commission. There was a reference to how many comments there have been at the FCC. And, comments come in all the time from all over the country on these types of services, yet she did not mention complaints. And again, there have been no complaints filed before the FCC as to the Maryland service of Securus in the past 2 years at least. We could go back and look probably further, and it would probably be even longer than 2 years. Worth Rises has also criticized this financial restructuring. The proposed transfer aims to reduce Securus's debt burden by over $1 billion. That is what is needed to enhance the financial stability and to preserve service continuity. Worth Rises in these allegations fails to recognize that financial restructuring is often necessary to preserve operations and financial viability. If we didn't have that, it could disrupt services for incarcerated individuals. Worth Rises has totally mischaracterized private equity ownership. It overlooks that many utilities and many service providers operate under similar structures with regulatory safeguards in place. The assumption that all private equity investors, or most of them or some of them, will exploit consumers is overly broad and unsupported. As to preserving service continuity, the transfer here is designed to ensure uninterrupted service for incarcerated individuals and their families. Worth Rises' opposition risks destabilizing a critical communication infrastructure without guaranteeing a better outcome, sorry. And in the, I guess the final point that Worth Rises makes, I think they're relying a little bit on emotional narratives. While that's important, it should not override objective policy evaluation. Last point I would make is there's a concern about the owners, and in this case, the lenders. Who are they? What would they do? What would they be? And earlier you heard the Office of People's Counsel state that we have not provided the information on who those lenders were other than the top two who had the largest percentage shares. That is inaccurate. In response to question 1-5 of OPC's data request, which was proffered to us on September 9th, the company responded on September 15th with a full list under a title capitalization table. It literally provides to OPC every single lender and their percentage share of the ownership as a result of the transaction if it were to go through. So the idea that we are withholding information or that there's not enough information that's been presented or vetted, that we respectfully disagree with that characterization. We have provided full information, full disclosure, not only of these owners and every single one of them, but also every single member of the board, every single member of the management. The board and management members' staff has reviewed and determined that they do possess the requisite skill and experience to oversee a company providing this service. With that, I'm happy to answer any other questions or comments. Thank you.
May I respond to? Yeah. I don't think that I said what counsel just said I said. If I did, it was in fact a misstatement, and I'll direct the commission to footnote 8 in OPC's letter filed a couple days ago, where we say the parties have identified those additional parties and their respective anticipated interest in a data request from OPC, but have marked their response confidential. So we have seen those. The commission has not. They're marked confidential. Neither has Worth Rises. So the fact that they've disclosed them to us under confidentiality doesn't do a lot to advance this conversation. Thank you.
Commissioner Linton.
Thank you, Mr. Chairman. I actually have a question for the People's Council. So your office falls under the Attorney General's purview. And we've just heard from Worth Rises that there is a matter in which the Attorney General is engaged in with Securus, excuse me. Could you describe or tell us what's going on in that matter, and if it has any relevance to the Commission's noting this filing here today?
Thank you for the question, Commissioner Linton. I am not familiar with that. And I'm also not exactly familiar with the relationship, the statutory relationship between our office and the Attorney General. I think there is some sort of relationship, but we are an independent agency. We make our own decisions. The Attorney General makes his own decisions about cases to pursue. So I'm not familiar with that litigation, but I can certainly look at it. And as far as I know, OPC has not participated in informing that litigation decision.
Okay, I guess there could be some impact, and I'll appreciate any follow-up you could provide, but I just want to make sure that we're not impacting that proceeding by doing something here today, and I don't know what that proceeding is about, so I can't.
I think that's a very valid concern, Commissioner Linton. I think Ms. Tylek probably knows more about that litigation, perhaps, and the AG's position in it, but I can certainly provide more information if the Commission would like.
Okay. Thank you. Thank you, Mr. Chairman.
Anybody else? Okay, so since apparently there is an open question as to what our authority is, we're going to take this matter under advisement and check with our lawyers to see what is the extent of our authority under our current statute, and then issue either a notice or a ruling at some point in the future. So, and with that, I guess we're adjourned. So.